Hi everyone, welcome back to Hands-Free Studying for the MBE with Brainscape. Today's video is about criminal law, so get ready and let's get started with our first set of cards covering fundamentals.
Question 1. What are the elements required to prove a crime? First, you have the actus reus, which is a voluntary physical act. 2, you must have the mens rea, which is the requisite mental state. 3, there must be concurrence, meaning that the mens rea must exist at the same time as the actus reus. And 4, there must be causation, either cause in fact or actual cause, plus proximate cause. Question 2. What's the burden of proof for each element of a crime? Beyond a reasonable doubt. Question 3. Define actus reus. Actus reus is the voluntary physical act or omission required by a crime. Question 4. Are habitual acts, which are conditioned reactions, considered voluntary acts? Yes. Question 5. What are examples of involuntary acts? Examples of involuntary acts include reflexes, bodily movements during unconsciousness or sleep, actions during hypnosis, or a bodily movement that is otherwise not the product of the effort or determination of the actor, either conscious or habitual. Question 6. Do involuntary acts satisfy the actus reus? Generally, no, but there is an exception. It will satisfy the actus reus if the defendant is aware that they have a condition that can result in involuntary actions, and the defendant failed to take reasonable steps to prevent such actions. Question 7. Are acts performed under duress considered voluntary acts? Yes. However, note that duress can be a valid defense, so check out the deck on defenses for more. Question 8. When does failure to act constitute the actus reus? If 1. There was a legal duty to act, 2. The defendant was aware of such duty, and 3. The defendant could have reasonably performed the act. Question 9. Under what circumstances is there a legal duty to act? There are generally 3 scenarios. First is if there's a special relationship, for example, parent-child relationship. Second, if there's a statutory or contractual duty, for example, either a firefighter or lifeguard. Or third, if there's a voluntary undertaking by the defendant that leaves the victim worse off than before. Last up, question 10. Define mens rea. Mens rea is the defendant's state of mind during a crime. The defendant must have a culpable state of mind to be convicted of a crime. This can be manifested through either knowledge or intent, but generally, each crime will spell out what the requisite mens rea is. These upcoming questions are related to criminal law, homicide concepts. Let's get started. Question 1. What are the elements of common law murder? The elements of common law murder are the unlawful killing of a human being with malice aforethought. Question 2. What is the actus reus and mens rea for common law murders? The actus reus is the act that results in the death of another human being. The mens rea is malice, which can be either express, for example, with intent to kill, or implied, for example, such as in felony murder. Question 3. What are the types of malice? There are two: express and implied. Question 4. How is malice established? Malice is established with either intent to kill, which is considered express malice, intent to inflict grievous bodily harm, which is considered implied malice, reckless disregard for human life, also implied malice, or intent to commit a felony, also implied malice. Question 5. How does a defendant act with an intent to kill? The defendant acts with an intent to kill when they act with the purpose to kill or the knowledge that it is substantially certain that death will result. Question 6. What constitutes intent to inflict grievous bodily harm? Intent to cause serious bodily harm without an intent to kill. Question 7. What are the elements of depraved heart murder? The elements of depraved heart murder are reckless or grossly negligent conduct that creates an extreme risk to others and that demonstrates a wanton indifference to human life. Question 8. What are the elements of felony murder? Felony murder is an unintentional and foreseeable killing proximately caused during the attempt, commission, or flight from an inherently dangerous felony. Question 9. What are inherently dangerous felonies? Inherently dangerous felonies are felonies that create a substantial risk of death or serious bodily harm. Some of the common ones you can remember by the mnemonic BARK. Those include burglary, arson, robbery, rape, and kidnapping. Under the MPC, felonious escape is also considered an inherently dangerous felony, and these can be identified by statute and/or through case law. Question 10. Can a defendant be liable for felony murder if the underlying felony is not inherently dangerous, but it was committed in an inherently dangerous manner? Yes. These upcoming questions cover criminal law, other crimes against persons. Let's get started. Question 1. What are the elements of criminal battery? Criminal battery is the unlawful application of force to another person that causes bodily harm or constitutes offensive touching. Question 2. What is the mens rea for battery? Battery is a general intent crime, which means that the mens rea requires that you have the intent to cause the harmful contact or offensive touching, not that you intended the harmful result. Now, note, in most states and under the MPC, the mens rea can be satisfied if the defendant acted recklessly or in a grossly negligent manner. Question 3. What circumstances elevate a misdemeanor battery to aggravated battery? Misdemeanor battery can be elevated to aggravated battery if the defendant either causes serious bodily harm, uses a deadly weapon, or has intent to kill or intent to rape. Question 4. What are the common defenses to battery? 1. Valid consent. 2. self-defense or defense of others, or if the battery was necessary to prevent a crime. Question 5. What is assault? Assault is either an unsuccessful attempt to commit battery, also called attempted battery assault, or placing another in apprehension of immediate harm, also called apprehension assault. You're doing great so far. Let's take a quick study break to remind you to take your headphones or AirPods with you when you go for a long walk or workout, so you can listen to these videos whenever your hand's free. Remember, every little bit counts. All right, let's get back to questions 6 through 10. Question 6. When does a victim have reasonable apprehension of imminent harm? When the victim reasonably anticipates that the defendant's acts will result in immediate bodily harm, and this is a subjective standard. Question 7. Differentiate between battery and assault. Battery is either bodily harm or offensive touching, whereas assault is attempted battery, or an act that places the victim in fear of immediate harm. No touching is required for assault. Question 8. Do verbal threats constitute assault? No. The words must be in conjunction with an overt threatening act or gesture to constitute assault. Question 9. What circumstances elevate assault to aggravated felony assault? If the assault is committed with a deadly weapon, with intent to rape or kill, or if the victim is specially protected by statute. Question 10. Define common law mayhem. Mayhem is a crime that disfigures or permanently disables the victim. Nowadays, it's equivalent to modern aggravated battery. These upcoming criminal law questions cover property crimes. Let's get started. Question 1. What intent is required for theft offenses? The intent required is the intent to permanently deprive. Question 2. What constitutes an intent to permanently deprive? An intent to permanently deprive requires that the defendant intend to keep the property, abandon the property, destroy the property, or hold the property for ransom. Question 3. What is the doctrine of continuing trespass? The doctrine of continuing trespass states that if a defendant takes property without the intent to permanently deprive, and then later decides to keep the property, the defendant will be considered to have the latter intent at the time of taking. In other words, the defendant will be guilty of larceny. Question 4. What will negate the intent to steal? A defendant can negate the intent to steal if they have an honest belief of claim of right, no matter how unreasonable this may be, or if the defendant had the intent to restore the exact property. Question 5. What are the elements of larceny? The elements of larceny are the trespassory taking of personal property in another's possession with the intent to permanently deprive the owner thereof. Question 6. If the defendant originally intended to permanently deprive, but then later decided to return or abandon the property, what is the defendant's criminal liability? The defendant will be guilty of larceny due to their original intent, even though they later changed their mind. Question 7. Can you be guilty of larceny if you are in lawful possession of the object at the time of taking? No. There must be an unlawful taking to constitute larceny. Question 8. Under common law, is a defendant guilty of larceny for failing to return or report lost or mislaid property? Yes, the defendant will be guilty of larceny if, at the time of finding, the defendant intended to keep the property, that he knew or had reason to know had a rightful owner, and he failed to take reasonable steps to return the property. Question 9. How does the MPC treat lost and mislaid property? Under the MPC, a defendant is liable if he fails to take reasonable measures to restore the property. Now note that the key difference between the MPC and common law is that under the MPC, the finder's intent at the time of finding is irrelevant. The only thing that matters is whether or not the defendant failed to take reasonable measures to return the object with the intent to permanently deprive the owner. Question 10. What are the elements of larceny by trick? The elements of larceny by trick are fraudulently obtaining possession of property owned by someone else with the intent to permanently deprive. These upcoming criminal law questions cover inchoate crimes and parties to a crime. Let's get started. Question 1. Define inchoate crimes. Inchoate crimes are incomplete crimes. These include attempt, conspiracy, and solicitation. Question 2. What is the mens rea for attempt? The mens rea for attempt is that you must have the specific intent to commit the underlying crime. Question 3. What is the actus reus for attempt? The actus reus for attempt is that the defendant must take some overt act in furtherance of the intent to commit the underlying crime. Question 4. Can you be charged with attempt for strict liability crimes or crimes that have a mens rea of recklessness or negligence? No, because attempt requires specific intent to commit the underlying crime. However, if the defendant knows that a result is practically certain to occur, then the requisite intent may exist for an attempt charge. Question 5. What are the 3 tests to determine if there has been an overt act for attempt? The 3 tests to determine if there has been an overt act for an attempt is first the dangerous proximity test, which is used by a majority of jurisdictions. Second is the equivocality test, which is used by a minority of jurisdictions. And 3, we have the substantial step test, which is used by the MPC. Question 6. What is the dangerous proximity test? The dangerous proximity test looks at whether the defendant came within dangerous proximity to completing the crime, or so near to the result that the danger of success was very great. Question 7. What is the equivocality test? The equivocality test states that an act is overt when the defendant's conduct is an unequivocal manifestation of their intent to complete the target offense. Question 8. Under the MPC, what is the substantial step test? Under the MPC's substantial step test, an act is an overt act if it is 1. A substantial step in the course of conduct planned to culminate in the defendant's commission of the crime, and 2, is strongly corroborative of D's criminal intent. Question 9. Does mere preparation qualify as a substantial step? As a general rule, no. It must go beyond mere preparation to qualify as a substantial step under the MPC. Question 10. What are some examples of actions that are considered substantial steps under the MPC? There are 6 main examples that the MPC describes. The first is lying in wait, or searching for or following the contemplated victim of the crime. 2, enticing or seeking to entice the contemplated victim to go to the place that you're going to commit the crime. 3, watching the place contemplated for the commission of the crime. 4, unlawfully entering a structure, vehicle, or enclosure in which the crime is going to be committed. 5, possessing or collecting materials that serve no lawful purpose under the circumstances. Or 6, soliciting an innocent agent to engage in criminal conduct. These upcoming criminal law questions cover defenses. Let's get started. Question 1. What are the 2 general types of defenses? First, you have capacity defenses, for example, insanity or intoxication. And second, you have justification defenses, which include self-defense. Question 2. What are the tests for insanity? There are 4. The first is the McNaughton test. Second, irresistible impulse. 3, the Durham or New Hampshire test. And 4, the Model Penal Code or MPC test. Question 3. What are the elements of the McNaughton test? The elements of the McNaughton test are first, that the defendant suffered from a mental disease or defect in reasoning, and second, that the defendant was unable to understand the nature and quality of his act, or not able to understand that what he was doing was wrong. Question 4. What is the irresistible impulse test? The irresistible impulse test looks at whether the defendant is incapable of controlling his own behavior. Remember that many states will use both the McNaughton and the irresistible impulse test. Question 5. What is the Durham, New Hampshire test? The Durham, New Hampshire test states that the defendant will be acquitted if his actions were the product of a mental disease or defect. In other words, but for the defendant's mental disease or defect, he would not have committed the crime. Question 6. What is the MPC test for insanity? The MPC test states that as a result of mental disease or defect, the defendant lacked substantial capacity to either appreciate the criminality of his conduct or conform his conduct to the requirements of the law. Success under either the McNaughton test or the irresistible impulse test will satisfy the MPC standard for insanity. Question 7. What are justification or excuse defenses? Justification or excuse defenses argue that the defendant's conduct was justified under the particular facts of the case. These types of defenses include self-defense, defense of others or defense of property, necessity, duress, crime prevention, and entrapment. Question 8. What are the elements of self-defense? The elements of self-defense are that first, the defendant honestly and reasonably believed. 2, that he was subject to an imminent unlawful use or threat of force. And 3, the defendant used proportional force to defend himself. Question 9. When can first aggressors claim self-defense? First aggressors can only claim self-defense if first they have completely withdrawn, communicated that withdrawal to the victim, and then the victim reattacks or continues attacking the defendant in light of that information, or they've used non-deadly force and the victim then responds with deadly force. Question 10. Can a victim act negligently when using self-defense? No. The victim may not act in a manner that a reasonable person would find inappropriate. You must only use force that is proportional.
And that's the end of our criminal law study round.
To reach full mastery, remember to study in Brainscape. Our mobile and web app uses the latest in spaced repetition techniques, allowing you to optimize your study time and track your progress down to the finest detail. Of course, when you're driving, cooking, exercising, or otherwise unable to navigate the app, be sure to keep listening to the rest of this hands-free studying playlist. No matter what subject you're learning and what method you're studying it, Brainscape helps you rise to your challenge.